Hello. Today on the Nicholas Custer Show, we are going to examine the two Supreme Court decisions that came out yesterday and a couple days ago. The first one on affirmative action, the second one on the the website creation case up in Colorado. And we are going to go through the majority opinion as well as the excellent concurrence by Justice Lawrence Thomas, and also the dissent by Ketanji Brown Jackson, and we're going to compare those two. And the the left wing media is completely freaking out about both of these. So we are going to examine their reactions to both of these cases as well. So here, here we go. So first, we're going to go through both of these. Cases, and I'm going to first examine this case. So, first of all, we're going to examine the majority opinion. It was written by Chief Justice John Roberts. And so we're going to go through that. So Justice Roberts is he basically guts affirmative action, but he does try to leave a little wiggle room there at the end to as not to look too partisan and to protect the what he calls the integrity of the court, because Justice Roberts is really fond of protecting the integrity of the court by not doing his actual job. But in this particular case, he gets it pretty much right. So first, he says, in in, in Rudder v. Ballinger, the court for the first time endorsed Justice Powell's view in Bakke back in 1978. That was the first affirmative action case. Um, that a student body diversity is a compelling state interest that can justify the use of race in university admissions. The greatest majority analysis tracked Justice Powell in many aspects, including insistence on limits as to how universities may consider race in their admissions programs. those limits is, were intended to guard against two dangers. Justice Roberts says. The first is the risk that the use of race will devolve into illegitimate stereotype, meaning that you don't want colleges in 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 admissions assuming assuming a person's economic status or level of hardship, um, based on their race or how good they are at school. The second risk is that it will not be used as a plus, but as a negative to discriminate against those racial groups who do not, um, fall into the affirmative affirmative action category, like Asians or Jews, for example, which have been hurt by affirmative action programs for years because on average, Asians and Jews work harder in school and they get better test scores, which hurts them in affirmative action pro- programs because they can't all be let in to make room for African Americans and other racial groups that do not perform as well as they do on average. A, 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 university's use of race accordingly could not occur in a manner that undoubtedly harmed non-minority applicants. To manage these concerns, Grutter imposed one final limit on race-based affirmative action programs. At some point, they must end, and Grutter said in about 25 years. And Grutter was decided in 1993, so we're already on year 20 when this case came down a couple days ago. Then he concludes because Harvard's and UNC's admissions program lacks sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints, those admission programs can't be reconciled with the guarantees of the Equal Protection Clause. At the same time, and this is where Roberts puts a carve out in place, kind of gives universities some legal room, although not much. They might try to use, um, this as a carve out. At the same time, nothing prohibits universities from considering an applicant's discussion of how race has affected their lives, so long as the discussion is concretely tied to a quality of character or unique ability that a particular applicant can contribute to the university. So you could see a situation where a student writes an essay about their race, um, and the universities could find a way to use that somehow as a proxy to do um, to to do racial um, affirmative action in some capacity. But still, under this ruling, that would be hard to do. Now we are going to do Clarence Thomas's concurrence, and it is a masterpiece, as it always is with Clarence Thomas. Clarence Thomas says in his concurrence, in the Jim Crow era, the court finally corrected course. He's talking about Plessy v. Ferguson before this. The finally corrected course in Brown v. Board of Education, announcing that primary schools must either desegregate with deliberate speed or else close their doors. It then, he says, pulled back in Grutter B. Ballinger. He says, permitting universities to discriminate based on race in their admissions process through only, though only temporary, in order to achieve alleged educational benefits of diversity. Because we all know if you're around people of different races, that automatically means your educational experience is going to be better for no reason. Otherwise, we think all races think alike apparently, or all people of the same race think alike apparently, which is patently stupid. But that's what the left thinks of this country. He he continues, yet the Constitution continues to embody civil truth. Two discriminatory wrongs can't make a right. The use of race in higher education admissions, um, regardless of whether it is intended to help or violates the 14th Amendment. And then we are going to get to Ketanji Brown Jackson's view of race. And Clarence Thomas just lights into her like her Christmas tree. It's quite beautiful to watch or to read, I guess. Justice Jackson has a different view. Rather than focusing on individuals as individuals, her dissent focuses on the historical subjugation of Black Americans, in, invoking statistical racial gaps to argue in favor of defining and categorizing people by their race. As she sees things, we are all inexorably trapped in a fundamental racist society with the original sin of slavery and the historical subjugation of Black Americans still determining our lives with the passage of the 14th Amendment. He says, our nation proclaimed uh, that the law may not sort citizens by race, and its principle that the framers of the 14th Amendment adopted in the wake of the Civil War to fulfill the promise of equality under law. And it is this principle that has guaranteed a nation of equal citizens the privileges or amenities of citizenship and the equality of the laws. And then he says about Jackson's dissent to dismiss the 14th um, um, Amendment as two dimensional flatness is to abdicate a sacred trust to ensure our honored dead shall not have died in vain. And he's quoting Lincoln in the Gettysburg Address. Justice Jackson would replace the second founder's vision with an organized principle based on race. In fact, in her view, almost all of life's outcomes may be may be tied to race. We're still, Justice Jackson uses her broad observations about the statistical relationships between race and select measures of health, wealth, and well being to label all Blacks as victims. Her desire to do this is unfathomable to me. I cannot deny, he continues, the great accomplishments of Black Americans, including those who succeeded despite long odds, given the lengthy history of given the lengthy history of state-sponsored race-based practices in America. To say that anyone, oh, and then so this is now Ketanji Brown Jackson's um, dissent. She says, given the lengthy history of state-sponsored race-based preferences in America, to say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fails to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry, which she provides no evidence for whatsoever. Instead, rather just points it to inequality of outcome and say that equals discrimination. It is that inequality, she says, that in Michigan programs just 40 that in Michigan programs just 4 years ago in 2000 that in Michigan programs are 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 trying to correct. Just 4 years ago in 2019, black families median wealth was approximately $24,000. White families, for white families, that uh, number was approximately $188,000. These wealth disparities exist at every income and education level. Make no mistake, when an applicant chooses to disclose his or her race, UNC treats that aspect of identity on par with other aspects of the applicant's identity. So I have a question. Why? Why is that important? Why is race important? Well, because in their mind, all all members of racial groups think alike effective because all members of racial groups, especially minority groups, have the same experiences to one another, or almost identical experiences at the very least. That which she continues, other aspects of their identity that affect who they are. It permits but does not require them to value. In her example, she uses James's race not in the abstract, but as an element of who he is. Because obviously, your race is a great determining factor in who you are as a person, of course, because you know my wheelchair determines who I am as an individual human being, what my work ethic is, how how good am I in school. it's it's very determinate, of course, because I because I don't know why. Because it just must be apparently because the left today is just as racist as John C. Calhoun or David Duke because your your race is a big chunk of who you are. mm, she continues, no less than his love for his state, his high school courses, and the obstacles he has had to overcome. So, so she says that his high school courses and his race are are equally a, 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 equivalent, and his his race is one of many obstacles he's had to overcome. Apparently, a, 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 according to her, she even goes as far as to okay. She even goes as far as to, in this opinion, where is the excerpt from? Oh, here it is. She even goes so far as to say, I'm going to use the New York Times article because the article has the same quote, and it's easier to see. The article was written by her, Abby Then Sickle. It's down here at the bottom. She even goes as far as to say, quote, the takeaway from Clarence Thomas's opinion, or this is from her. The takeaway is that those who demand we stop thinking about race is to we refuse to see it, much less solve for it. The race linked disparities that continue to impede achievement of our great nation's full potential. So basically, what she's saying is you can't stop thinking about race, because if you stop thinking about race, you will you will be unable to solve the racial problems this country faces. So we will never stop thinking about race. We must continue to think about race over and over and over again, which is really, really gross and really abhorrent. But these people believe that race is as important as your worth, work ethic, or anything else that you do in, in life, apparently. Now I wanted to turn to two video clips. The first one is going to be on CNBC. And I want you to listen to this lady's answer if you can hear it. So basically, if we get rid of affirmative action, what she says there is that if we get rid of affirmative action, our enrollments of different minority groups will fall off significantly. So instead of, actually fixing the problem, which you would encourage two-parent households, you would encourage a higher emphasis on on education in racially in up, up in poor and in impoverished communities like the inner city, for example, where where a lot of African Americans reside, and there's drugs and there's violence, not because they're black, but they because that small sect of people is poor because they don't have a father in the home. And it's a repetitive cycle. So instead of fixing that, what we should do is we should help African Americans get into these schools, even if it means more qualified applicants don't get in, and it means that um, a lot of these minority groups end up flunky out, let alone that these racial admissions programs violate the 14th Amendment of the Constitution. But she doesn't care about that. She just wants to get the the outcome that she wants to get because she doesn't know how the court works. Fair. And then the second video we're gonna watch comes from ABC. So 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 the anchor, I forget the anchor's name. I see her all over the place because I watch ABC, but I forget her name. Um, but she's like the um, mm, number of black Americans is going to fall from 7% to 4%, or fell from 7% to 4%. Aren't you worried about these groups of people not getting in? And and the dark horse president of Jakarta, whose name I cannot say, I'm sorry, says, no, I'm worried. I'm more worried about un, un, underqualified members of those groups getting in and then not being able to complete their their courses, which is what happens is they tend to struggle. And even if they don't, even if they did, it still is a clear violation of the Equal Protection Clause. You cannot have an applicant that is more qualified than another applicant, or any applicant for that matter. You cannot pick one over the other based on their race. You can do it, which Clarence Thomas says in this plea. You can do it based on hardship, based on economic status. If they have the same scores and one's a first generation college student and the other is like a seventh, he says absolutely you can take that into account because the first generation you can assume had to work harder to get the same score, but you cannot judge that based solely on race or based at all in race, because race has nothing to do with how hard you work or the hardship you have to endure. See, they're assuming that because you're a member of a certain race, you have a certain hardship, or you're of a certain economic status, which the 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 the, the Grutter decision essentially said you're not allowed to do, and that's what these two colleges were doing. And the Supreme Court said you're not allowed to do any of that. So they basically gutted the entire affirmative action program because the UNC and Harvard were using race in a very small way to begin with. So it's effectively gutted, although Clarence Thomas just came out and said he can't, you shouldn't be able to consider race at all. So he would have gone even a little bit further by just getting rid of it completely. Whereas I said earlier, Justice Roberts left the door open at least a little bit, but I can't see how race-based affirmative action in college will continue given the narrow scope, but we'll see what happens. And then in the other case, the the Christian website designer case, we're we're gonna see how how they decided that case. It was written by Justice Neil Gorsuch, so that's a plus. John Roberts let Justice Gorsuch write the opinion. So he goes through the examples that they used regarding the speech in previous cases because Gorsuch mainly focuses on free speech and not freedom of religion, which I think is a negative, although it is sprinkled in throughout the opinion, but it's mainly focused on speech and expression. And I would rather him come out and say, at least more expressively, no, you're not you're not allowed to ban religion from the public square, essentially. If you're in a private business, you're allowed to express your religious beliefs within your businesses. So I would have liked to have seen them express that more clearly, but it's still a very well written and solid opinion. So we're gonna start off by an excerpt from the opinion. Veterans veterans organizing a St. Patrick Day parade in Boston. This is from a previous case. Refused to include a group of gay, lesbian, and bisexual individuals in their event. The group argued that the Massachusetts public accommodation statute entitled it to participate in the parade as a matter of law. However, state or whatever, sorry, a state law may demand. This court explained that the parade was constitutionally protected speech and requiring the veterans to include voices that they wish to exclude would impermanently require them to alter the expressive content of their parade. So he's pointing back to this case and he's saying, we said in this prior case that if we force this certain group to allow these certain individuals into their parade, it would alter the message of the parade or the protest. We part ways, he says about this case, we part ways with the 10 Circuit's opinion in this case only when it comes to the legal conclusions. So basically, the 10th Amendment said exactly what this court said, except they found that the state of Colorado was right to do what they did or fell within their legal authority. And the Supreme Court said, no, no. We part ways with the 10th Circuit only when it comes to the legal conclusions that follow. While the court thought Colorado, in this case, could compel speech from Mrs. Smith consistent with the Constitution, our First Amendment precedents idle later above teach otherwise. In Harley, the court found that the Massachusetts impermissibly compelled speech in violation of the First Amendment when it sought to force the parade organizers to accept participants who would affect their message. In Dale, which is another case, the court held that the New Jersey Boy Scouts that New Jersey intruded the Boy Scouts' First Amendment rights when required a point of view contrary to their beliefs. That would be homosexuality by directing its membership choices. And then Barnett, this court found impermissible a coercion, coercion when West Virginia required school children to recite the Pledge of Allegiance. That was with a case involving Jehovah's Witnesses. Their convictions on threat of punishment or expulsion. Here, Colorado seeks to put Mrs. Smith in a similar choice. If she wants to speak, she must either speak as the state demands or face sanctions for expressing her own beliefs. Consider what the contrary approach would mean. Under Colorado's logic, the state may compel anyone who speaks for pay on a, a, a given topic to accept all commissions on that topic, no matter the underlying message. So basically, the court protected religious liberty and religious freedom by saying Colorado could not compel her to make a website for a same-sex couple, which violated her religious beliefs. And as we'll see, the media's treatment of this was just absolutely ridiculous. We'll start with um, our friends over at the New York Times. Um, and this is by Ruth Graham. The headline reads, the court delivers another reassuring decision for religious conservatives. She writes, conservatives who have a moral and theological objection to gay marriage saw the court's decision on Friday as reassurance that they would be able to assert their beliefs in the public square that they see as increasingly hostile to them. Oh, I wonder why. I wonder why. Could it be news outlets like the New York Times? As we'll see, she does not seem at least fond of this opinion. In a 6-3 vote split along ideological lines, the justices agreed with a web decider in Colorado who said she had a First Amendment right to refuse private services for same-sex marriages, despite a state law that forbids discrimination against gay people. And then she reads an excerpt from the Gorsuch opinion. And says, and then she quotes a head of the Southern Baptist policy arm. Its subjugation, said Brett Leatherwood, head of uh, the Southern Baptist, in a statement after after the ruling. He described the decision as having guaranteed freedom to all to speak consistently with their beliefs, even if those beliefs are deemed culturally unpopular. Then Graham here cites a poll saying that the majority of most major religious groups, including Catholics, Jews, and Muslims, oppose allowing small business owners to refuse to serve gay and lesbian people on religious grounds. First of all, who cares? Second of all, I doubt that that poll is accurate. I sincerely doubt that mm, mm, most Muslims, for example, are in favor of being forced to put um, positive LGBTQ messages on their work or to participate in same sex marriages. I sincerely doubt. And I would like to see what Catholics you talk to get, or they talk to get this poll data, because it's wrong. I I I would venture to guess. And then she says notable exceptions include white evangelical Protestants, because after all, we have to include race. Have to. We must, because it's all the minority groups against the white Christian religious people. Evangelical Christians, how dare they? And the Church of Modern Day Saints, i.e., the Mormons. Yeah, so there's that. The ruling on Friday comes a day after another Supreme Court decision shared by religious conservatives. This ruling was uh, about a um, mailman who wanted to observe the Sabbath on Sunday, and his job wouldn't allow him to. And the court ruled in his favor, which is great also. In Colorado, Mrs. Smith and her lawyers emphasized that her objection is not to work is to not work with the same-sex couples or gay individuals, but designing websites for gay weddings. So she's perfectly willing to make a website for a birthday celebration, or like a family trip, I would presume. But she's not willing to celebrate a same-sex wedding, which seems perfectly reasonable to me. But I'm a bigoted, bigoted homophobe apparently. So what do I know? But designing same-sex weddings. Similar cases have centered around conservative Christians, small business owners who object to working on gay weddings. specifically a baker in Colorado. And two designers in Arizona and a photographer in Kentucky. And in a news conference shortly after the ruling, she says, Christian Wenger, the general counsel for Alliance Defending Freedom, which helped Miss Smith out in this case, compared her client to a Muslim baker asked to make a cake critiquing Islam, or to a Democratic speechwriter forced to promote a Republican candidate. Then she ends with, well, many conservative Christians hailed the decision on Friday. It drew criticism from progressive Christians. In other words, Christians who don't go to church very often, or at least read the Bible to mean whatever they want it to be. And interfaith groups, including those that serve gay people of faith. And and she quoted for the executive director of New Ways Missionary. Broad exemptions to allow religious-based discrimination hurts people of faith too. Yes, because if we actually impose our standards, we are discriminatory because, after all, who cares about that silly book anyway? So, and then another article here in the Washington Post um, says, and this is by um, Laura Fieldman or Fieldman of Bloomberg wrote this. The Supreme Court's ruling weakens civil rights for all. Wow, that's dramatic. Dum dum dum. Oh no, we can't enforce. We our 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 secular religious moral scriptures on those damn Christians. Oh no, how will we survive? In a defeat for equal rights, according to her. The Supreme Court ruled that a Christian website designer may refuse to make a same-sex wedding website for gay couples, despite a Colorado civil rights law. Because it's a civil rights law, that means it's automatically a good law, of course. That prohibits discriminating against gay people in their business. The 6-3 decision written by Justice Gorsuch broke down along this court's standard ideological lines. It is yet another victory for the conservative majority and should be seen as part of the court's sharply right-wing turn. Ooh, how dangerous. We've used the court at our beck and call for the last 50 years. And now the right-wing Nazis have control of the court. How will we survive? Ooh, oh no. They're actually reading the Constitution. I can't believe the horror. How dare they read the actual words written in the document? The decision is not only bad for gay people, she says, who want to have a wedding website made in Colorado. So you're telling me that she's the only website designer in all of Colorado. You're saying that due to our major in that technology, there's not any way that they can design their own website relatively easy, or find somebody else to make their website for them. Like many couples I know get help with their 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 wedding website creation. I can't imagine that she is it would be the only website designer in Colorado. In fact, she hasn't even started hers yet. So how did this couple, or how have gay couples in Colorado been able to uh, market their wedding dates without her present? I mean, surely all the gay couples are sitting there waiting for her to start her business and be forced to cater them, because obviously they haven't been able to do it any other way, of course. But anyway, the decision is not only bad for gay people who want to have their wedding website made in Colorado. From a legal perspective, there's exactly zero difference between civil rights laws protecting gay people and laws protecting Black people. Um, well, first of all, um, civil rights laws protecting gay people legitimately fall in conflict with freedom of religion. That's the first problem. The second problem is yes, actually, I I would prefer a world where the Civil Rights Act of 1965 was redefined as far as its language with regard to public accommodation, as to include as to exclude private businesses, and just include governmental entities, because I think that forcing any private business to serve whomever violates freedom of association and freedom of assembly. So yes, I would be in favor of those laws getting struck down too. But there is a unique distinction between these two cases. That doesn't mean, by the way, that I want businesses discriminating against African Americans or anybody on the basis of an actual mutable characteristic, but I would rather have that than than people be forced to serve whomever comes through their doors because of arguments made like this one. But I do think there's a distinction there. The website designer could have refused to make a website for an interracial or interfaith wedding. What has, first of all, no, that's not what the opinion says. Second of all, in what world in 2023 would that ever happen? First of all, you find me, find me a find me a story. You're a reporter, find me a story in which that has happened in the last, I don't know, 10 years, 20 years. Find me a story, please. Because there's a one. You can't find one in the last 10 years because it doesn't happen in 2023 in the United States. So quit with the with the with the oh, overreaction. I mean, my God. The court issue in this case, she says, is the conflict between two twin constitutional values, equality and liberty. Okay, so like yes, yes, and 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 to understand this, we have to understand that the last definition of equality is basically everybody gets the same outcomes and liberty to them. They have no concept of liberty, at least when it comes to for freedom of religion. They would like all religious expression to be restricted to inside a person's own home. They reject the idea of religion being allowed in the public sphere. They've railed against cases that allowed a football coach to to pray with his team at the center of the 50-yard line and the other team, and it was completely voluntary. But the left wing on the court said in their dissent, thank God, no, you can't do that because the kids might in in interpret you're praying as they must pray, even though you expressly said that it was voluntary, which is absolutely ridiculous. Because all they want to do is make traditional religion exiled from the public square so that they can impose their own secular religion upon everybody else in the United States, which is your your sexual on the authenticity is the only thing that matters, as well as your race. Your race matters a whole lot because it is determinant of the obstacles you've had to overcome because of the systemically racist country that you live in, and it your race and sexuality in their minds determine who you are. So that is why you will see the transgender community and the gay and lesbians, and bisexuals I have nothing in common really, are grouped together because of opposition to traditional ways of thinking and traditional morality. So yes, and that is it for episode 1 of the Nicholas Custer show. We will continue episode 2 when I get back from the 4th of July. Have a have a great weekend and set off some fireworks, and also remember that we are living in the greatest country in the world, and is and the most freest country in the world. And a special thanks to those who who are in charge with keeping it that way. Thank you very much, and God bless you. Thank you. Bye. Come on. Stop.